Good afternoon, everybody. Josh Weisberg from IDAX & Sons. Thank you for joining us today for our webinar. I believe that we are ready to get started, and I will turn the mic over to Michael Dax, principal at IDAX & Sons, to give us a brief intro before Leah and I kick things off.
Thank you, Josh. Good afternoon, everyone. Thank you for joining us. If there's anyone here I haven't had the pleasure of meeting, as Josh said, my name is Michael Dax, one of the managing principals here at IDAX & Sons. Whether you deal with me or you deal with another member of the DAX organization, undoubtedly you've heard about risk transfer. It's something we talk about often. If you've been practicing good risk transfer, we commend you, we salute you. And if you haven't, you've definitely come to the right place. Either way, we invite you to settle in, grab your popcorn, and get ready for a great and extremely pertinent presentation from two amazing members of our team, our General Counsel, Leah Krautmanis, and our Chief Risk Officer, Josh Weisberg. Guys?
Okay, Leah, I think you're up first, and then I'll come in after.
Great. Thank you for the intro, Michael, and welcome everyone. As Michael mentioned, I'm General Counsel here at IDAX & Sons. In that capacity, one of my primary roles is to oversee a team that reviews contractual indemnification and hold harmless language. And so in that role, definitely very aware and focus for our clients on making sure that there are strong risk transfer mechanisms in place. So going to the next slide, we're going to talk through our agenda for this webinar and the general overview of what we'll be discussing. So initially, we'll be talking about risk transfer on a high level and overview, then going into indemnity and hold harmless contractual indemnification. After that, we will transition into additional insured coverage within your insurance policies. Following that, we will talk about putting all of these risk transfer tools into practice and tendering a claim, and we will end with any questions from participants on the information that we've gone over.
Okay. Sorry. Yeah, so as Leah mentioned, my name is Josh Weisberg. I'm Chief Risk Officer here at IDAX & Sons. I partner with Leah on all things risk transfer, which we're going to talk about, as part of a kind of a broader umbrella of best practices when it comes to managing your insurance program. Leah will talk about contractual indemnification. I will talk about additional insured status. But in a nutshell, what is risk transfer? I mean, Michael mentioned it before. You've heard about it a lot from IDAX. It is taking a loss and moving it from your insurance program over to another party's insurance program. And that can be a general contractor, that could be a commercial tenant, it could be any third party that you're doing business with. So for example, if a construction worker gets hurt while repairing a leaking pipe inside one of your buildings, and that construction worker decides to file suit against the property owner, against the general contractor, against some other third party, including yourself, including your company, the question becomes, does your insurance policy have to respond for that loss, or is there somewhere else that we can move it? And if we can move it over to a general contractor or to a commercial tenant, that reduces the amount of money that your insurance company is paying out on claims. And the more we reduce the amount that your insurance company is paying out on claims, the more we can contain the premium, the cost that's associated with your insurance program. And the stakes here are huge. As Michael said, they talk about risk transfer all the time within DAX. We talk about risk transfer all the time within DAX. And there's a reason for it, because every single one of these personal injury lawsuits is worth an enormous amount of potential money that your insurance company might have to pay out in the event that you do get sued. And these numbers are only going up. What you see on this slide, this is just a representative list of jury verdicts that were reached in 2024 in New York City alone. So we're talking about principally the Bronx, Brooklyn, Queens. What are juries doing with these kinds of claims, these construction accident claims, your more conventional slip and fall, trip fall kind of personal injury lawsuits? They're awarding more and more money to plaintiffs. And the more money that they award to the plaintiffs, the more it costs the insurance companies to pay out on these losses. And if it's your policy that has to pay out, ultimately, that's going to lead to an increased premium. So what we want to go through today is, what are those best practices? What are the best ways to take a $23 million loss, a $10 million loss, for a $7.6 million loss, make sure it's not sitting on your insurance policies, but rather sitting somewhere else? Because the more successful we are at this, the more contained your insurance premium is absolutely going to be.
Great.
Leah, you're up.
So moving on to the general overview of what we'll be discussing today. As Josh has already mentioned and Michael mentioned up top, risk transfer on a very, very high level is shifting of liability from one party to another. There are various mechanisms that this can take place through. They're the types of risk transfer that we're really going to be focusing on today for the purposes of this webinar and relative to your insurance programs, as Josh mentioned, are contractual indemnification and then additional insured coverage. So I'll kick it off by moving on to the first piece of that, which is indemnity and hold harmless. So it's common for businesses or organizations to agree in writing to take on the liability of somebody else, perhaps liability they wouldn't otherwise have. And this form of agreement where one party takes on the liability of another by contract is commonly called hold harmless or indemnification. And there's different types of hold harmless or indemnification provisions that you're going to see in your lease or your general contractor or service provider agreement. And you want to pay close attention to these, the form of indemnification, contractual indemnification that's provided, because this will lay out the scope of the indemnification or the risk that can be transferred to another party. If you are the party that is providing the indemnification, you're the indemnitor, and if you're the person who's receiving it, you are the indemnity. Broad form is a form of contractual indemnification where the indemnitor is assuming all legal liability regardless of fault. So you're going to pay for losses arising out of accidents, even those which were 100% the indemnity's fault. We'll talk a little bit about some caveats to that on the next slide. A more common, or one that you'll see often, is an intermediate form where an indemnitor will assume all legal liability except where the other party, the indemnity, is solely at fault. And you can try to narrow the indemnification language in that way. And then a limited form indemnification is where an indemnitor will only pay a portion of a loss that's directly related to its percentage of fault. And this is sometimes called a comparative fault agreement because you're only paying that portion of loss that's directly related to your percentage of fault. So you're not really contractually shifting any of the, of the liability. You're kind of assuming your own percentage of the liability. This is separate and apart from your insurance policy. This is language that's sitting inside of your, like I said, your lease or your general contractor or other service provider agreement. So you want to be looking both at your insurance policy as well as any contracts that you're signing as a landlord or as a tenant or as a GC, and make sure that the risk has been properly allocated between the parties. And depending on if you're the indemnitor or the indemnity, you will want the language to be broad. If somebody else is indemnifying you, you want that language to be very broad. And if you are indemnifying someone else, you would want to look at that language and try to tailor it and make it as narrow as possible to limit the scope of your contractual indemnification obligations. One reason that could be important is because a commercial general liability policy will provide some insurance coverage for contractual indemnification obligations, but it's limited. So you want to make sure that your contractual indemnification obligations are as narrowed as possible so that your insurance policy could potentially respond. There are also some other limitations here. Contractual indemnification for your own negligence is permissible in New York unless there's a statutory provision voiding the same. So there are a couple of key limiting statutes in New York. Pursuant to the General Obligations Law 5321, a provision in a lease seeking to exempt a party from their own negligence is void and unenforceable, but you can look to insert savings language in an indemnification agreement that could potentially provide partial indemnity even where the agreement might violate one of these limiting statutes. So you always want to look for this language to the fullest extent permitted by law in your contractual indemnification provisions, because that can allow you to work around these limiting statutes. And other states have similar statutes or case law as New York. So that's another thing you want to be mindful of, is the governing law for your contract, because that will dictate if there are any applicable limiting statutes that might come into play.
Right, just to kind of build on Leah's point about the contractual indemnity. Obviously, what we're looking to do here is, like, just take an example. Let's say you're running a portfolio of commercial properties and you have a series of commercial tenants that are in that building. The indemnity should be built out in a way, if you are the landlord, the indemnity should be built out in a way that provides that the landlord is going to be indemnified, meaning fully protected for claims that arise out of the tenant's use of the space. So, for example, if somebody slips and falls inside the store, or if there's a customer that happens to slip and fall on the sidewalk while they're going into the store, or into the building rather, those are two different scenarios where the indemnity might be triggered if it's this broader form of indemnification. So from the landlord's perspective, if that's who you are, as you're building out these contractual indemnification provisions, whether it's in a proprietary lease or it's in a construction agreement, you want to make sure that you're stretching that as much as you can. And there's a rationale behind that, which is you want to make a tenant indemnify you for use of the demised premises. Why? Because they're, generally speaking, in control of the demised premises. You want to make a general contractor or a subcontractor indemnify you, meaning protect you against those personal injury lawsuit exposures. Why? Because they're in control of their own work. So if you're in control of your own work and you're in control of your own demised premises, your own leased space, it stands to reason, it makes sense that they should be protecting you, not the other way around. And I can absolutely tell you, and Leah can attest to this, and so can Michael, when we bring a risk to an insurance company and say, this is a risk that we would like you to quote, one of the first things that they're going to ask, if it's a property portfolio, let's say it's mixed use residential apartment buildings in New York City, or it's a general contractor, or rather a property developer that does ground up construction throughout the 5 boroughs, one of the first things that they are going to ask absolutely is, I want to see a template of your construction contract. I want to see a template of your proprietary lease, because they want to know that you're doing exactly what Leah just said, which is stretch that indemnification, get the broadest possible protection that you can, so that I know that if and when there is that slip and fall claim, I'm going to be able to flip that claim either to the commercial tenant or to the subcontractor or to the general contractor. So this is critically important, again, to moving those losses away from your own insurance program, but also to get you the most competitive rate when you go out for renewal or you're going out to a new insurance market. They're going to want to see that you have this best-in-class risk transfer. And it's that broad indemnification that absolutely gets you there. So when we look at indemnification, that's one part of a lease or a construction contract that helps you effectuate this risk transfer that we're talking about. There is another provision or another series of provisions that are built into any proprietary lease, any construction agreement that also can give you risk transfer. So you have 2 different roads. The other one is what's commonly called the insurance requirements or insurance procurement language that's built into these agreements. And we're going to talk very basically about what that really means. What it means is, let's use a general contractor as an example. Let's say you're a property owner and you're engaging a general contractor to do an interior renovation for an office space for a tenant that you're going to be bringing into the building. Well, you're going to engage the general contractor. They're going to agree to indemnify you, as Leah just really did a great job of outlining for you. And then they're also going to be obligated within that general contractor agreement to maintain certain kinds and levels of insurance. And then within that section of the agreement that talks about the kinds and levels of insurance that they have to maintain throughout the course of the job, they're also going to give you what's called additional insured status on their liability insurance policies. And we're going to talk about precisely what that means in a moment, but I want to make it very, very clear. And this is something that we see clients trip up on constantly. Saying in the agreement that, or requiring in the agreement, that the general contractor buy insurance is not the same thing as saying in the agreement that they're going to buy the insurance and they're going to give you additional insured protection. If you don't have the and, if it doesn't say we're going to include you as an insured, meaning we, the general contractor, are going to include you, the owner, as an insured in writing in the contract within that agreement, then guess what? All you've really done is made sure that they have insurance. You're not going to get that additional insured protection. And additional insured protection is critical. No disrespect to Leah, no disrespect to contractual indemnification. But if you were going to put a gun to my head and say, Josh, which would you prefer? Additional insured protection or contractual indemnity? I'm going to say additional insured protection every single time, and twice on Tuesdays. And we'll talk a little bit about why that's the case in a couple of minutes. You definitely want both, but the additional insured protection is absolutely critical. Why is it absolutely critical? Well, contractual indemnity and additional insured coverage absolutely do not go hand in hand. First and foremost, contractual indemnification, you're relying on the assets of your general contractor or your commercial tenant to pay for the indemnity. Remember, that's an agreement. The agreement to indemnify is an agreement between you and the tenant, you and the general contractor. However, if there is a requirement for additional insured status, well, then you just took on a contractual relationship with the insurance company of that tenant or that general contractor. So I don't have to worry about how much money the general contractor has to indemnify me. All I have to worry about is, have I triggered coverage as an additional insured on that general contractor's insurance policy? And now I get the millions upon millions of dollars in cash that insurance company has to defend me and to indemnify me. The other practical piece, really the practical distinction between indemnification and additional insured status, is that an insurance company has an obligation upfront to defend you as an additional insured, whereas a contractual indemnitor, meaning that commercial tenant or that general contractor, that upfront obligation doesn't exist. How does that work in practice? I'll give you a perfect example. If a lawsuit comes in and it says that the commercial tenant somehow or another was responsible for a trip and fall claim, but they also say that you as the landlord are equally responsible for that liability related to that trip and fall claim, well, the indemnity piece is essentially held kind of in a cryostasis. It's frozen. You don't get the benefit of that indemnification until it's proven that the claim or the injury arose out of the tenant's use of the demised premises. And that can take a very long time for the courts to unwind. On the other hand, because it's possible that it was related to the tenant's use of the demised premises, the obligation of the insurance company to pay for your defense of that claim, meaning the tenant's insurance company, to pay for that defense of that claim for you kicks in right away. They have to immediately assign a lawyer. They have to make sure that they're protecting you as an additional insured. And that is a very big difference. So you're not waiting for indemnification for years while the lawsuit is pending. You're getting coverage right away. Those are, if you were to ask me, what are the two critical distinctions between indemnification and additional insured status? Those are it. I don't have to worry about how much money the indemnity has. I don't have to worry about how much money the indemnitor has. All I have to worry about is how much money the insurance company has. That's number one. And number two, that coverage is triggered right away as an additional insured, as opposed to having to worry about that indemnification being triggered much, much later on when it's proven that your commercial tenant or your general contractor actually caused the injury. So how do you go about building out these insurance requirements? Again, this is all about contract drafting. And I should say, and we haven't said this yet, of course, in any situation where you're on the fence or you're unclear as to whether or not your contract does these things, meaning you're not sure if your lease gives you good contractual indemnification, or you're not sure if the lease gives you good insurance protection from your counterparties, send it to us. Send it to the team at DAX. We will absolutely help you review those agreements and make sure that we have the right language, because it's the language in these agreements that triggers everything. If it ain't in the contract, we can't do much with it. And if it ain't in the contract, your insurance companies are not going to be happy about that. So the way you build out these insurance requirements is in writing. It's in the lease, it's in the construction agreement or it's in your general contractor's agreement. And it says, you, contractor, are going to include me as an additional insured on your general liability policy. If you're a general contractor, same thing. You, subcontractor, are going to include me as an additional insured on your commercial general liability policy. That's the basics. That's the core, the essence of the secret sauce starts right there. But there are other kinds of insurance that you're most definitely going to want to make sure are in that agreement, meaning that, again, if you're a property owner and you're working with a commercial tenant, you're not just going to want commercial general liability. You're going to want a whole menu of other insurances built into that contract to make sure that you are fully protected as the property owner. And that can take the form of excess liability insurance and business auto liability insurance if they're going to be operating autos in and around the building or the property, and certainly workers' compensation insurance for their employees that are going to be operating within the space. But the point is, you should be relying on the advice that we at DAX can provide to you about which pieces of the menu, which parts of the menu of different insurances should we be including in the agreement. But the point is to ask. The point is to make sure that we're getting the most comprehensive protection that we can in terms of the types of coverage, and then again, the limits of insurance that we're going to be requiring, because that must be included within the agreement as well. So for example, you're going to say, I want $1 million commercial general liability policy from you, Mr. Tenant, and I want to make sure that I'm also getting workers' compensation insurance on a statutory basis, and I want $1 million auto liability policy as well. If it's in writing, if it's in the agreement, then it's enforceable, and then we can work on triggering coverage. Here on this slide, you really get a full sense of not just the types of insurance, not just the limits of insurance, but what else must be in the agreement to make sure that if and when the claim comes in, we are going to have no issues transferring that risk as an additional insured from your policies over to that tenant or over to that general contractor or subcontractor. And without getting into too much of the minutia about these various different bullets, these must-haves, but I can tell you that whenever we're drafting template language for one of our clients, we make sure that every single one of these bullets are in there, meaning you're going to get additional insured status under the tenant's policy with specific types of language that's built into that additional insured status. We have to make sure we're getting the right kind of additional insured coverage. We're going to make sure that that coverage, meaning the tenant's coverage, is primary. That means the tenant's coverage goes first. If there's a loss that's worth $10 million, we want to make sure that the first $10 million worth of coverage is going straight from the tenant's policies, and it's never going to come from your own. The only way we can make sure that happens is if it is contractually required in your lease or in your general contract that the tenant's insurance or the general contractor's insurance is primary. It goes first and you go last. Only after all of that tenant insurance and all that general contractor insurance is exhausted, then your insurance as the property owner or as the developer of that construction project, only then does your insurance go. If you don't include that, you can enter into all sorts of scenarios where your insurance might have to go first, even though you're still an additional insured on that tenant's policy. So it's definitely something that needs to be stipulated and expressly stated within your contract. We also want to make sure, and this is probably something, those of you that have been working with Michael and the DAX team, you're definitely going to be familiar with what's called action over exclusions or limitations. We want to avoid those wherever we can. And you want to expressly say in the contract, there cannot be any action over exclusions or warranties that are built into your commercial tenant policy or into your general contractor policy. And in a very, very kind of like 50,000 foot view perspective, really in a nutshell, action over exclusions, I apologize, action over exclusions are designed to eliminate coverage for what's called labor law claims, meaning injury to employees of a contractor, injury to employees of a subcontractor. And the reason why that's so important is that especially in the city of New York and in the state of New York, those kinds of claims are worth tens of millions of dollars. If you go back to the first slide where we talked about the stakes, every single claim that I put up there, $23 million, $10 million, $5 million, $7 million, Those were all action over claims. So it should come as no surprise that insurance companies love to exclude those kinds of exposures. The only way to avoid that kind of issue is to require within the agreement that your subcontractor, your general contractor, your commercial tenant cannot have action over exclusions in their liability insurance policies. And if they do, they're automatically in breach of the agreement and they're going to have to go out and get new insurance. And I just want to briefly just give you, I'm always about show and tell. I'm always about trying to find the right document to kind of link up what we're talking about here. What you see in front of you is an actual additional insured endorsement, a real live coverage endorsement that's fairly standard within the industry. This is what you are going to want to get. You're going to want to make sure that that commercial tenant, that contractor is giving you an additional insured endorsement, a standardized form that says, we will provide you with additional insured protection under our policy, A, so long as it's required by written contract, and B, so long as it's caused by the acts or omissions of the commercial tenant or the general contractor. If you have all these ingredients, meaning we've got the additional insured endorsement on the actual policies themselves, and we've got the right language in the contract requiring them to maintain these kinds of endorsements, you're in very, very good shape, and we have a very, very good chance of getting that risk transferred. And again, doubling down on the show and tell, this is what it all should look like. When you're drafting insurance requirements for any deal that you're working on, this is how it all spells out. This is how it all comes into practice. And this is what the agreement should look like when it's closed and finalized and fully drafted. And you'll see, and I think you can see with my arrow here, what have we built into this template insurance requirement? Well, we're requiring workers' compensation, employer's liability insurance for the employees of the contractor. We've got that. Great. Excellent. We've got the right amounts of insurance, meaning limits for general liability insurance. That's in there. You can see the primary non-contributory. That's in there. You can see the right kind of additional insured endorsements. That's also in there. And then you can see here in subparagraph 5, you've got that no action over exclusions. You can't have any kind of exclusions that are going to bar coverage for those nasty action over claims that can cost you so much money if you don't have the right kind of coverage coming from that contractor or coming from that commercial tenant. That's how it all takes shape. One more important note, and this comes up all the time. Michael and I have this conversation constantly with DAX clients. I get this, I've got a certificate of insurance. The certificate of insurance says they've got the right kind of limit. It lines up with the agreement. I've got a great written contract. Look at this gorgeous certificate of liability insurance. It spells it all out. I'm good to go. Absolutely not. A certificate of liability insurance is never enough to prove that that contractor or that commercial tenant has the insurance that is required by the contract. The only way that you can ever confirm that the insurance lines up with what the tenant is obligated to provide or the contractor is obligated to provide is getting actual copies of the policies themselves. You must get the tenant's policies. You must get the contractor's policies, send them over to DAX so that they can review them and make sure that those policies are in compliance with what you agreed to in that written contract. And the way that you know that certificates of insurance are essentially non-binding, and if I could be so bold, basically worthless, is look at this language over here. The certificate is issued as a matter of information only and confers no rights upon the certificate holder. It means it's not legally binding, just making this as plain as I possibly can, and the certificate means nothing if and when a claim happens. If the policy doesn't cover action over claims, it doesn't matter if the certificate of insurance said, don't worry about it, Mr. Commercial Property Owner, I don't have any action over exclusions. Irrelevant. The policy controls, not the certificate of insurance. And if the policy has action over exclusions, it ain't going to matter what the certificate of insurance has to say. So we've built out our contract. We've got good risk transfer language. Leah did a bang-up job with great indemnification. It's really broad. Josh did a great job of building out a perfect mousetrap of insurance requirements. We've looked at all the policies. We've blessed them. They're kosher. Everything lines up with what's in the contract. What happens if and when there is a claim? Well, the first thing you're going to do is call DAX. That's number one. Or you're going to email DAX and you're going to let them know right away that you have a claim. The next thing that's going to happen is DAX and our claims professionals are going to ask you, okay, we've got a personal injury lawsuit. It's a slip and fall claim. It's right outside one of our commercial buildings. Do we have any source for risk transfer? Is there a target that we can identify that we need to tender this loss to right away, along with their insurance companies, so that we're taking that risk off of our own insurance policies and moving it somewhere else? And that can be a lot of different targets. It certainly can be that general contractor if there was construction work going on in the building. It could absolutely be your commercial tenant if it relates to their use of the demised premises. It could be a vendor that supplied you with contact mats if it turned out that somebody slipped and fell in the lobby and there was a defect related to that mat. But that's the first step, identifying the potential targets, and then we start gathering information. And we're going to tell you, and your insurance company is going to tell you, get me the names of the companies that might have been involved in causing this loss, and then get me the contracts, get me those certificates of insurance so I know who the insurance companies are. And most importantly, if we have them, get me those insurance policies. As soon as that's all gathered, as soon as that's all put together, your insurance company is going to prepare a written tender demand, which means essentially a letter to the insurance company and to your contractual counterparty, that tenant or that general contractor, saying, pursuant to the terms of our written agreement, I am entitled to liability insurance coverage on a primary basis. This lawsuit is your problem, it ain't my problem. Assign defense counsel, assign a defense attorney to represent me. This is going to be on your insurance policies. It's not going to be on mine. If it all works the way that it's supposed to work and we've teed it up the right way, the tender gets accepted. The claim closes on your loss run, meaning your loss experience with your own insurance company, and everybody on your side of the ledger is very, very happy. The claim gets paid by the commercial tenant's insurance policy or by the general contractor's insurance policy, and the goal of risk transfer has been absolutely achieved. And as you can see here, there's a myriad of different ways. There's lots of different ways to skin this cat. You could have a janitorial contract, an elevator contractor, if it's an elevator-related malfunction, snow and ice removal contractor, if you third-party out snow and ice removal, delivery companies, the possible targets and the scenarios in which you can hit all these different targets come up all the time. You rely on DAX and your insurance company to help you identify these targets and then to work the tender, meaning work that risk transfer for you to make sure that the general contractor's insurance company or that commercial tenant insurance company is picking up the loss. And as you're building out this, let's call it this tender file, these are all the documents that your insurance company is going to want to see. They're going to want to see witness statements. They're going to want to see daily logs. They're going to want to see photos of the accident area. All of these different pieces can help bolster the argument that the loss was caused by the operations of the tenant or caused by the operations of the general contractor, which again, as I said before, that's the trigger for additional insured coverage. So long as there's a shot that that's the case, the additional insured status is triggered and the liability insurance for the tenant or for the landlord is going to be implicated, and that tender is going to get picked up. So kind of summing it all up, bringing it back to square one, it starts with the agreement. If a claim comes in 5 years from now, and that absolutely can, because the life of these contracts can go on for many, many years, we're not going to have a chance to rework that agreement. We can't go back in time and change it. We can't go back in time and change the certificate of insurance. We can't go back in time and change the language of the insurance policies. The only way to get this right, the only way to win the risk transfer game is to have an ironclad contract that's drafted from inception that gives you that broad indemnification that Leah mentioned, and that has those key ingredients to insurance requirements or insurance procurement built in now. The claim comes in 5 years from now. We now have the great contract. It says I'm entitled to indemnification. Yay for me, Mr. Property Owner. It says that I'm entitled to additional insured status and full liability insurance protection. Excellent for me, Mr. Property Owner. I've been collecting certificates of insurance year after year from my tenant that prove that they have or that establish at least potentially that they have the right levels of insurance and the right terms. And I've been collecting those policies because I've been trusting, but I've also been verifying. The claim has now come in. I send that to my insurance company along with good language within these contracts, plus the certificate, plus the policy, plus all of that investigative information related to the underlying personal injury lawsuit. You have the best possible chance in that circumstance of succeeding in risk transfer and getting that claim flipped. And I cannot stress, I said this before, and I'll say it one more time. Every contract that you're working on, by all means, if you have questions, bring that back to the DAX professionals, bring that back to us, ask us, am I looking at a good indemnification? Am I looking at the right insurance requirements? I want to have template language for my insurance requirements. We can provide all of that to you because, as Leah mentioned before, and as I'll mention again, this is the world that Leah and I live in. I'm an insurance coverage litigator by trade. My job is to make sure that these risks get flipped. My job is to make sure that they get appropriately tendered. We're both attorneys that have worked these kinds of losses for 20 plus years very successfully. So you should be relying on the expertise that we have in this space, relying on the expertise that Michael and the balance of the DAX team absolutely bring to this space. And collaboratively, we absolutely can assist you with this. It helps with keeping that loss experience down, better premium, and it also helps us market your risk. There are going to be more insurance companies interested in quoting your business if they know that you've got strong contract language and strong risk transfer habits. I'll stop there. I want to thank Leah for doing a bang-up job as part of this presentation. Michael, I want to thank you for putting it all together. Any questions at all, you certainly can certainly shout them out now. You can put them in the chat, but you're also more than welcome. Our contact information is right here. So if you have any questions, you can certainly get back to us and we'd be happy to help you. You also can, of course, get in touch with Michael. And he can answer any questions, or he can direct you to folks within DAX that can answer any questions that you have.